So, I'm sorry. Oh, not all. Yeah. I'm looking.
Okay. I'm the quarantine. I can understand that. Yes. You can do if they have somebody out there,
All right, I'm ready whenever.
Wait a minute.
All right, calling case 21-1203-01-FC, People's State of Michigan versus Brian Martin here today for a pretrial appearances for the record.
Dominic DeGrazia on behalf of the people.
Good morning, Your Honor. Good afternoon, rather. Eric Rosie on behalf of Mr. Martin.
I'm Brian Mark.
All right.
My father's family I wanted to do a long time. They didn't get my letter. I tried to send you a letter to them. So, my statement of remorse. I've been trying to do that a year ago, but I'm sorry it's too late. I mean, it took me so long to say it.
All right, we're here for a final conference. Mr. Goes was somewhat recently appointed to this case. There were several motions filed by Mr. Goes's predecessor counsel. I did issue my opinions on the motion to suppress and motion to dismiss. And today I will give counsel a copy and Mr. Martin a copy of my order denying the motion to dismiss based on a speedy trial violation. So I can give that to everyone that you can take with you today.
Thank you.
All right, what other outstanding issues do we have on behalf of the defense?
Thank you. Mr. Martin has filed subsequent to my representation, and since my representation, several pro per motions which he wishes to argue at this particular time. Most important to me was the due process motion. Is that correct, Mr. Martin?
Yes.
And I would yield my time to Mr. Martin. He also filed a bill of particulars. I don't know if the court has that in its possession as well.
I did see in the some of the, can you, Melissa, give a copy of this to Mr. Goes, one Mr. DeGrazia? Those are copies. Yeah.
Thank you.
I did see in some of the submissions that Mr. Martin had submitted to the court, he had requested that he be allowed to proceed with hybrid representation.
That's correct.
And so I just want to make it clear today that a defendant has the constitutional right to represent himself or to be represented by counsel, but not both. There is no constitutional right to hybrid representation, nor does hybrid representation compromise defendant's right to proceed pro se. The decision to grant or deny hybrid representation lies solely within the discretion of the trial court. A criminal defendant has no constitutional or statutory right to represent himself as co-counsel with his own attorney. So therefore, going forward, the defendant may not file any pro se motions while at the same time continue to be represented by counsel. So now that I've put that in writing, so you understand, you may not proceed with hybrid representation.
The judge is saying that she's not going to listen to the motions you filed on your own. Do you understand that? You would have to go through me.
That's just fine. That's fine.
All right, so Mr. Goes will represent you going forward.
With that, Judge, as it relates to the motions for the bill in particular, the charges against him is open murder. And as the court is aware, open murder encompasses one of three theories of defeat. First degree premeditated, it could be second degree murder, or it could be manslaughter. Given the nature of the facts that will be before Your Honor has had a chance to read the transcript because the motion to quash was filed by prior counsel. And it does boggle the mind as to how the people could proceed forward and have this court instruct on a first degree premeditated murder based on those facts. So what is the people's theory to argue ethically even that this is a first degree murder versus a second degree versus a manslaughter? I believe that's what the concern Mr. Martin had specifically as it relates to this, notwithstanding his absolute right to self-defense.
See if I can pull up that motion.
Court doesn't have one on
Let's see. Do you have the file, Melissa, that I gave back to you? Do you have the date on that one? That might help.
Sorry about that.
Okay.
Mine is dated May 3rd, 2020.
Oh, thank you, Mr. Wright.
Thank you. See. From May 3rd. I'll see it in there. Your response to the bill for particulars?
Judge, in my experience, courts of order need to produce the particulars that would be quite rare. Typically, those are in situations with, complex embezzlement cases or complex conspiracy cases where, there may be confidential informants or there may be reasons why the people could not present information in police reports, but is intended to be used at trial. That is not the case here. The facts of this case are not really in dispute at all. The defendant knows full well the evidence that's going to be presented against him. The defendant himself has admitted repeatedly throughout his motions, reiterated and supported the facts of the case as being supported by the people. The whole case really turns upon whether or not the fact finder believes the defendant's claim for self-defense. And that's really all the case is. This is not an extremely complicated case involving convoluted legal theories. This is simply, do you believe the defendant when he says that he had to act in deadly self-defense to defend himself? I view this motion as simply an attempt by the defense to saddle the prosecution with busy work or paperwork, just to simply frustrate the people's case or to add one more list of things for the people to do. But in terms of, will a bill of particulars make the facts of this case any clearer for the defense? I would suggest to you that it wouldn't. And as far as the second argument, well, what basis do the people have to support a charge of first-degree murder? I've made this argument repeatedly, both at the exam and throughout the course of these motions. There is evidence on the record, and it will be argued at trial, that the defendant had an opportunity to premeditate and to deliberate before he ended up shooting the complainant. The facts of the preliminary exam, and I believe by the defendant's own statement, were that after the initial argument with the complainant, the two of them went inside the home, Mr. Martin's home. Their argument continued. Mr. Martin at that point grabbed a firearm, followed the complainant outside the home, and that's when the shot was fired. That's our argument, and our perspective is that once the defendant is in a place of safety inside his own home, and he makes the decision to go leave the home, follow the complainant outside to, whether it's to continue the argument or to ultimately kill the complainant, that is sufficient evidence for the fact finder to determine that the defendant acted with premeditation and deliberation, that the defendant had an opportunity to think twice and to take different acts before he ultimately killed the complainant. So our theory is quite clear. The evidence is quite clear. There's nothing that I can tell that would be gained in a bill of particulars that would make this evidence any clearer for the defense. This is really just a simple case that needs to be decided by a trier of fact, and therefore I would object to the defense motion for a bill of particulars.
All right, I'll take your arguments under advisement and issue an opinion on the motion for a bill of particulars. What motion do you have next?
Judge, my client insists that I bring out a fact that should have or was brought out at the preliminary exam. That the fighting that people discussed was actually a fight that had occurred prior to.
Yes, we never argued.
It was a verbal altercation that occurred on the outside. And it never raised to the level of fisticuffs when it was brought back into that. That's wanted the record to reflect that.
All right, I'll review the transcript again.
We were fighting, all these chasing from the gun to the house, we were fighting on the porch. We was never arguing, he was fighting me all the time, in the house, all the way up the stairs, I was 2 feet away from my rifle, I grabbed my rifle.
Well, that's good to know.
But I
So
wasn't gonna do it.
he wants to point out that this was an antagonist.
Yeah, he was beating me up, and then he got away.
You cannot talk.
Okay.
And wanted it to be clear that he was being followed by this particular person who was assaulting him repeatedly and followed him into the home and brought him into the home and marched his way into the home, causing my client fear. Is that what you wanted to put on the record?
And I want to put on the record, when he left and he ran back, when he saw me standing on the floor, he ran back and charged me, started beating me up again.
Okay.
And he grabbed the rifle, and
You
that's when
cannot
I
talk.
had
You
to
gotta-
stop.
You have to speak through your attorney. So if you guys need to
Oh, I'm
confer,
sorry. I'm sorry.
and
I
then
think we got the record though on it.
Yes.
What do we say?
I will review the transcript
Thank you.
again from the exam in connection with the motion for a bill of particulars.
Thank you. Next, I believe, was a motion for additional discovery, and I think that this might have been fleshed out by prior counsel. A lot to do about, we'll get to that in a moment. A lot to do about the clothing that was taken from the decedent, that the decedent passed approximately 5 months go by, and before the body is taken from the morgue and then transferred to the funeral home. And in the interim, the clothing of the decedent was destroyed, burnt, which would have been able to be tested to determine close range shooting. And I believe that this court had issued a ruling stating that you're not going to suppress any evidence or deny it, but you will allow us rather to argue that based on what the testimony came out from medical examiners as well as the expert as to that the clothing itself could have very well have been at a close range shot, correct?
Yes,
And we would actually have a jury instruction, we could fashion one, which everybody agrees upon, to point that out, or at least allow us to argue that. Is that correct?
that the clothing could have acted as a filter.
Thank you. Thank
Yes,
you. That hence the gunshot residue test.
right.
Thank you. Next, you would also like me to argue about a due process argument. This argument is as follows, and that that he has not been afforded all of the discovery that he believes is or should be in the people's possession, specifically mental health records of the deceased, medical records of the decedent's prior drug substance abuse history, his military history as well, and his criminal record as well. Those should or are in the possession of the people. And obviously, Mr. Martin would ask this court to dismiss the case under the Brady rule for not tendering or turning that over. Is that correct, Mr. Martin?
That's correct.
I say everything you need me to say?
In evidence of the victim's character and his behavior.
Gotcha.
All right. This is the first I heard about the outstanding discovery in that area. Mr. DeGrazia?
Judge, I do not have any medical records, whether they be psychological, drug treatment related, physical, medical records of the complainant. I'm not aware that any exist. Obviously, I've not failed to turn any of that material over because it's not in my possession. And I'm not sure that any of those records do exist. I have no reason to believe that they do exist. Regarding the complainant's criminal history, I'm more than willing to look up any public databases to see if there's any criminal history related to the complainant in those databases. By law, I am precluded from having him run on the lien database or turning those records over to the defense because I don't have those records in my possession. So I'm more than happy to do what I can. I'm more than willing to comply with that, what I can do legally, but I'm not going to turn over lien records that I don't have, and I can't ask another person to run them for the defendant.
So is it my understanding that people are limiting themselves to 609 and 608? Michigan Rules of Evidence, 609 and Michigan Rules of Evidence, 608?
I don't remember what they are off the top of my head.
I apologize. 609 relates to prior acts of prior criminal convictions for truth, honesty, or false statement within the last 10 years. 608, I believe, is the not exactly other acts, but reputation evidence that he was the initial aggressor. So if there are any acts where he was an assailant or an assaulted person under similar or under any circumstances, I believe the defense would have a right to be able to see that and to look at that to thus shore up their defense that he was acting in self-defense. We have a history of a man who was a violent offender in the past.
Well, I'll respond this way. For the first part, crimes of theft, dishonesty, things of that nature. If there are any records of that nature in the publicly available databases, I will turn those over. Regarding these other acts where he may have been the aggressor, I don't have any of those documents in my possession. I believe those would be the subject of motion hearings, but I can inquire to see if there are any records down that road, and I guess we can address it in motions if there are any.
And as the people had indicated, I don't have access to the lien system, so I couldn't even to file a motion of that to say, maybe putting the people on notice that it's a fishing expedition. So if there is any criminal convictions, then the people would either turn that over, or they would object and request that I, argue it as to how it's relevant. So obviously, an in-camera inspection of that would be, appropriate under those circumstances.
All right, we could set a date for a motion hearing as to the potential criminal convictions that fall under 608.
If that's the
Yes.
correct, I might be wrong on the rule
Yeah.
of evidence. I'm kind of jumping off the top of my head there as well. I'm almost positive it's 608.
Yes, that is 608.
Okay.
And if there's outstanding discovery, we should hear that motion on that date as well regarding the records, psychological records of the complainant. I wasn't ever presented with a motion on that,
We
so
will get one to you shortly.
thank you.
And then is there one last motion? The judge said you made a speech, so she said no. No, you lost that. Is that the last one? Lastly, Your Honor, is a motion for bond once again. And while this may have been addressed in the past, however, I was successful in contacting 3 individuals, Ms. Brenda Moore, Mr. Winston Conyers, and Donna Montgomery, all 3 of whom have agreed to appear via Zoom. I hope that they have actually appeared via Zoom. Ms. Moore was kind enough to submit a letter to me, which I've given to the people. I presented to the court, indicating Mr. Moore's responsibility in the community. His reputation is being an upstanding citizen, someone who could be relied upon. And on top of that, Ms. Montgomery even indicated to me he could go and stay with her, which is nowhere near anywhere the complaining witness is his family, or the decedent's family, I should say, excuse me, are residing. Judge, this is a man with a traffic ticket on his record, yet he's still being held on this case. Yes, this is a serious offense. We understand what the penalty is if he's found guilty of any of the top 2 capital offenses, let alone the felony firearm. But notwithstanding that, Mr. Martin is as I indicated, never been in trouble, but he's also was the person that called the police, called 911, had taken this individual into his home, was trying to get him some help when things went south, and he was trying to defend himself. And that has always been our defense. He's been his statements to the police. He didn't shy away. He did everything he could to try to make the situation as best as possible. Even apologized over counsel's advice. He wanted the family to know that he is sorry this happened the way this happened. It's heartbreaking for him. And of course, that does little solace to the family, perhaps. But it shows you the character of this person. He's not a ruthless person that's out here looking for trouble, getting into trouble. In fact, quite the opposite. We feel that once we have our trial, he will be vindicated of his rights. But he's been in now for 21 months. No fault of his own. No fault of the court either because of COVID. We understand that. But nevertheless, still, reality is we strongly feel that he's going to be vindicated on his rights. We ask the court to consider all of that when assessing the crime.
All right.
And if Mr. Conyers, Ms. Montgomery, or Ms. Moore is online, I would invite Your Honor to ask them to speak on that as well.
They are on Zoom, but I did put them in the waiting room. So. Mr. Grazia?
Judge, this issue has been argued many times. I want to say this is maybe the fourth or the fifth time it's been brought to this court's attention. My recollection is that his bond has been reduced at least once, perhaps twice already. Now, to say that the defendant, through no fault of his own, finds himself in that circumstance, obviously I take issue with that. The defendant, may believe that he had every right to go and kill the complainant in this case. Obviously, we disagree. People may honestly believe they acted in self-defense, but that can still be murder. And in this case, it's really undisputed, again, that the defendant shot and killed a person. We believe he did so unjustifiably. And I think what is particularly important in this case is, we're essentially told over and over again that, oh, well, the defendant never, this is so out of character for him. He's never been in trouble before. He will do everything the court asks him to do. Well, throughout the pendency of this case, whether it's been at the district court, whether it's been at this court, the defendant has found himself unable to control his behavior, unable to follow instructions by the court, unable to simply sit quietly and listen as the court has been trying to handle this matter. He frequently has outbursts. He frequently needs to be escorted from the courtroom. And all that leads me to believe that the defendant will have issues following the court's orders if he's released on bond. I question whether the defendant is released on bond. He gets a ruling he doesn't like. Will he show up for trial? I don't know. I have no issue setting this case for trial, getting this trial done within the next few months if the court has any dates available. But to simply keep going to the well over and over and over again, hoping that the court will simply change its mind because they've been asked 4 or 5 times to change its mind, I don't think is reasonable. The court has made up its mind. The court has decided to leave the bond the way it is. I have not heard any justification on the record for why the court should change its mind now. So therefore, I'd ask that the bond remain the same.
All right, the court has considered arguments from counsel. Mr. Martin is charged with 1 count of open murder, 1 count of felony firearm. The court is familiar with the facts of this case from reviewing the preliminary exam transcript as well as regarding the motions that have been filed in this case. In considering the factors set forth in MCR 6.106, the court does find that Mr. Martin does have no prior criminal history. He doesn't have any prior failure to appear history. Court is concerned about the potential danger that Mr. Martin poses to the community based on the allegations in this case that he fired a gun at an unarmed person at close range. So that's why I have maintained that bond is reasonable at $250,000, 10%. However, based on having spent more time reviewing this case, I will grant the bond reduction. I do find that there are conditions we can put in place that would assure that Mr. Martin would not pose a danger to the community if he were released on bond. So the court will reduce his bond to $150,000, 10% with the GPS tether, and he must be on house arrest at all times. And will he be living with Ms. Moore?
No, Judge, he will actually be residing with Miss Donna Montgomery. Who lives on Riverview. I can write down that address. Spreading it out for Zoom.
Yes, you can give that to my clerk once we're off the record. All right, and we can set a trial date today. September 19th is a good date for me, if that works for either of you.
Judge, I have another trial that's supposed to start in front of Judge Van Houten on the September 20th.
Okay. About Monday, October 3rd.
Just read it for me, Judge.
All right, your trial date is going to be Monday, October 3rd at 9 a.m. And we can set another date for a motion hearing.
I would think an August date would probably be better, just so that we all have on the same page.
Yes, let's see. I'm looking at the week of August 22nd.
Any day that week, that should be fine.
Let Thursday, the 25th.
Perfect.
Is that good for you, Mr. DeGrazia?
Judge, my only issue is that I'm supposed to be in trial before Judge Baker. So if you want to do it like when I have a break, I can be available during a break,
I'm sorry, what time would you might be, oh, lunchtime,
like around noon.
noon?
Okay.
All right, we'll set a motion hearing for August 25th at noon.
Perfect.
All right, if you are able to post your bond, you're going to be on house arrest at all times, and you're not to have any contact with or be in possession of any weapons, and you can't live in a place where there are weapons. You understand? Okay.
And Judge, he's allowed to go to the hospital, to come to court, and to meet with his attorney. That would be the only exception.
Yes.
Okay, thank you.
Melissa, if you could make them a copy. Yes. Or I can ask Jason to. Thank you. Yes, yes.
Thank you for letting me speak.
Thank you.
Thank you, everyone.
And that's automatically set up too. Sorry.
Oh, yeah. Thank you, man. Perfect.
Yeah, I'll take this.
We're gonna- Thank you.
Thank you.
Take care, Donna.
I still cannot find the bill of particulars. I don't know.
The address, I'm sorry.
Yes.
No, it's okay, yes. Sorry.
Whenever you're ready. Her name is Donna Montgomery. Her address is 19.